Everybody is waiting. The jury in Donald Trump's hush money case began deliberations today on Wednesday over the 34 counts of falsifying business records that he's facing, and MAGA is already telling him to flee to a MAGA safe zone. I want to make sure you guys are caught up on everything going on because the jury has already sent 2 notes, so it's important that we're all on the same page. The 12 New Yorkers who will decide Trump's fate met for nearly 5 hours after listening to the judge's directions about how they should wade through the sea of complex legal issues that the case presents. Justice Juan Merchan reminded them of their commitment to impartiality and implored them to set aside their biases to decide the case on the facts and the law. Quote, "Jurors, you will recall that during jury selection you agreed that you must set aside any opinions or bias you have in favor of or against the defendant, and if you decide this case against the evidence and the law," said Judge Juan Merchan, "you must set aside any opinions and bias, and you must not allow any opinion or bias to influence your verdict." And toward the end of the day, the jurors asked to review testimony surrounding some of the key allegations in the case as well as the judge's instructions. They will hear both when court reconvenes on Thursday, tomorrow. So first I'm going to summarize the jurors' notes because that's what everybody wants to hear about. Then I'll summarize the prosecution and the defense's closing arguments. So at 2:56 today, a buzzer sounded in the courtroom, the signal that the jury had a message to share. Prosecutors Trump and his team filed in. Merchan said the jury foreperson signed a note requesting to hear the following transcript portions. 1. David Pecker's testimony regarding the phone conversation with Trump while Pecker was in an investor meeting. 2. Pecker's testimony about his decision not to finalize and fund the assignment of life rights related to Karen McDougal. 3. Pecker's testimony regarding a meeting at Trump Tower. And 4. Cohen's testimony about the Trump Tower meeting. The jury will be brought in and seated, and the transcript portions will be read to them. These are moments that were mentioned during the prosecution's closing arguments Tuesday. And then the buzzer rang a second time, and Merchan retook the bench. He said the jurors were requesting to hear his instructions again. He called them back into the courtroom to clarify whether they needed to hear all of the instructions or just a portion. Merchan said reading the sections of the transcripts that the jury requested would take about 30 minutes. He said he didn't need an answer on reading his instructions immediately and dismissed the jurors from the courtroom for the day. Merchan said the jury will hear the transcript portions they requested and his jury instructions when court reconvenes at 9:30 a.m. on Wednesday, meaning the first day of deliberations is ending without a verdict. I know everybody is a little bit anxious and nervous, but just know that MAGA supporters are more nervous than you could ever be. Newsmax host Todd Starnes said, "President Trump needs to get out of New York City right now, fly back to Mar-a-Lago or another state that will provide him safe harbor." And then Peter Henline on Twitter said, "The mood in MAGA land right now. Run, bro." They're saying Trump needs safe harbor like he's a civilian in some combat zone, when in reality he's just seeing the consequences of his own actions for the first time. Alright, let's move on to the jury instructions. So in order to find Trump guilty of falsifying business records in the first degree, jurors must conclude that he, quote, "conspired to promote or prevent the election of any person to a public office by unlawful means." They do not have to all agree on which type of unlawful means, though. Merchan explained 3 the prosecutors put forth. 1 is violation of the Federal Elections Campaign Act, otherwise known as FECA. 2 is falsification of other business records, and 3 is violation of tax laws. For the second one, falsification of additional records, the judge gave several examples of documents that can be considered beyond the checks, vouchers, and invoices at the center of this trial. They include tax records issued by the Trump Organization to Cohen, bank records associated with 2 of Cohen's limited liability corporations, and records related to a wire sent to Daniel's lawyer. Judge Merchan then explained the 2 elements jurors must consider to determine a verdict. After defining the terms in the New York statute that Trump is charged with violating, Merchan told jurors they must focus on 2 elements of the prosecution's case when weighing Trump's guilt or innocence. To find Trump guilty, the jury must determine that Trump, acting personally or with others, quote, "made or caused a false entry in the business records of an enterprise," and that he did so, quote, "with an intent to defraud that included an intent to commit another crime or to aid or conceal the commission thereof, echoing the language from the statute. He said the same instructions apply to all 34 counts, each of which correspond to a different business record. Quote, if you find the people have proven beyond a reasonable doubt each of these two elements, you must find the defendant guilty of this crime. Merchan said, quote, if you find the people have not proven beyond a reasonable doubt either one or both of these elements, you must find the defendant not guilty of this crime. And here are the fundamental principles that the jurors must adhere to laid out by Merchan. So Merchan laid out what he called the, quote, fundamental principles of our law that apply in all criminal trials: the presumption of innocence, the burden of proof, and the requirement of proof beyond a reasonable doubt. He told the jurors that Trump is presumed innocent and that they, quote, must find the defendant not guilty unless, on the evidence presented at this trial, you can conclude that the people have proven the defendant guilty beyond a reasonable doubt, referring to prosecutors. To do so, jurors can consider, quote, all the evidence presented, whether by the people or by the defendant. Merchan reminded them that they cannot draw a negative conclusion about the fact that Trump did not testify in his own defense, and that he is not required to prove that he is not guilty. Judge Merchan then says, quote, the burden of proof never shifts from the people to the defendant. If the people fail to satisfy their burden of proof, you must find the defendant not guilty. And if the people satisfy their burden of proof, you must find the defendant guilty. I've always found it interesting that in legal trials, you're not deciding whether the defendant is guilty or innocent. It's either guilty or not guilty beyond a reasonable doubt. And let's go over the basics of the prosecution's case against Trump really quickly. So as the jury considers its verdict, it's worth looking back on the basics of the prosecution's case. Trump is accused of signing off on a scheme to illegally falsify records with the goal of covering up the $130,000 of hush money payment made by Cohen to Daniels in 2016. The scheme was designed to subvert election law and keep the payment secret, prosecutors say. They alleged Trump falsely portrayed reimbursements for the $130,000 payment as monthly checks for ongoing legal services paid over the course of the first year of his presidency. I'm personally surprised he paid it all. Each of the 34 counts corresponds to a voucher, invoice, or check originating from the payments to Cohen. Through a progression of witnesses, the prosecution began their case by laying out a broader catch-and-kill scheme to suppress negative stories about Trump during the 2016 election. David Pecker was the CEO of American Media Inc., the parent company of the tabloid The National Enquirer, in 2016. A longtime friend of Trump, Pecker testified about how he, Trump, and Cohen devised a plan to prevent damaging stories about Trump from surfacing in the months leading up to the election. The Enquirer also published negative stories about Trump's opponents and positive stories about him. Pecker said the tabloid would run stories by Cohen before they were published. Pecker agreed to be the eyes and ears of the campaign during a meeting in Trump Tower in August 2015. He told the jury. The catch and kill effort resulted in 3 stories being suppressed, most importantly the ones by Stormy Daniels and Karen McDougal. In his closing argument, prosecutor Joshua Steinglass said that AMI's purchasing of stories on then-candidate Trump's behalf, in coordination with the campaign, amounted to an unlawful campaign contribution. Steinglass said it, quote, turned out to be one of the most valuable contributions that anyone made to the campaign. This may very well be what got Trump elected. At its core, this is a case about documents, and through witnesses like the Trump Organization's former controller Jeff McConney and Deborah Tarasoff, who handled the company's payroll, the prosecution walked the jury through the allegedly falsified business records and numerous documents that they argue support this contention. Prosecutors showed bank records, emails, text messages, and call logs over the course of the trial. They also showed 2 documents bearing the handwriting of Allen Weisselberg and McConney, laying out the repayment calculations for reimbursing Cohen, which they called the smoking guns. They wove together a timeline of events that they say can only lead to one conclusion: that the business records were falsified with Trump's knowledge, and that this was part of a larger effort to help Trump's candidacy and prevent voters from learning about potentially damaging information before the 2016 election. Let me know in the comments what you think is going to happen. I love hearing from you guys. Make sure you leave a like on this video, comment a blue heart, subscribe, and have a great day.